The high-profile case, which is the only state capture case which went to trial, saw suspects acquitted due to insufficient evidence by the state. For now, the case hangs in the balance as the NPA is appealing the judgment at the Supreme Court of Appeal. Judge Nompumelelo Kusha's judgment states that there were errors of facts. 5 of the 8 accused had applied to be released, while Dr. Dimakatso Morosi opted not to apply. Other accused include former Transnet board member and Gupta associate Iqbal Sharma, his brother-in-law Dinesh Patel, and former Agriculture Department officials Peter Tabete, Dimakatso Morosi, and Sipati Dlamini. Kusha granted Section 174 of the Criminal Procedure Act, which provides for the discharge of the accused at the close of a trial.
It deems to be noted already at this stage of the judgment that Mr. Cezula is, on this score, a single witness. His evidence, therefore, as both a single and an accomplice witness, stands to be treated with caution.
State witnesses, who were mostly department officials, could not take the heat. Simpiwe Mahlangu, a National Department of Treasury official, was the first state witness to take the stand. His admission was found by the defense to be inadmissible.
It is a significant failure by the state to have applied its mind properly as to the institutional proper of a prosecution against my client.
The state had to link the cash flow between the Gupta companies, Nulane Investment, and Islandside to the Bank of Baroda. Other witnesses who took the stand testified that Nulane was paid millions without banking details, a tax certificate, or company profile.
I refer to it as the department. There is not a tittle of evidence linking the company Islandside and Veronica Ragavan to any such dealings between those parties.
No such evidence with respect has been adduced in this court that in fact links accused number 4 to the Gupta family.
The state maintains that it has a strong case against the accused, this despite them providing copies instead of originals as evidence.
The court has to look at the evidence that we presented before you. And the question is, have we presented the prima facie case before this honorable court, upon which a conviction may result? And our respectful submission, my lady, is we have. We have succeeded in doing that to a point that we feel so confident that even a conviction at the end of the trial will ensue.
Iqbal Sharma, who is the sole director to Nulane, had this to say after the judgment.
Clearly, we're relieved and pleased with the outcome. But given the sort of damning judgment that was handed down, I'm quite angered. I'm quite angered that the state, the prosecuting authority and the investigators would have pursued a matter like this which had no merit to begin with. The judge was quite damning in her judgment, called it a comedy of errors of the millennium on behalf of the state and the investigators.
A legal expert says the 6 people who are accused in the matter have grounds to sue the state.
It's going to be up to the defense currently of what are they going to do after. Are they going to proceed with the malprosecution, or are they going to just leave the matter as it is?
The Supreme Court of Appeal has referred the state's application for leave to appeal for oral argument, this after it was denied leave to appeal by the High Court in August. Aphumelele Mdlalane, SABC News, Bloemfontein.